So there's a big difference between writing conceptually after reviewing an outline or watching a long video on the law, and taking the law and putting it into play within the gamut of an essay approach and strategy. A lot of reasons that applicants get low 55s and 60s on California bar exam essays is because they're writing conceptually. So they know what the essay is testing, what the call of the question is asking for, but they're not methodically presenting their IRACs and really knowing what issues to give in regards to the essay. So I'm going to walk you through my evidence essay approach. At CA Bar Style, I'm a stickler for making sure applicants have an approach that they've worked through, that they've connected with, and the approach definitely takes a lot of twists and turns as you're working through it, so that by the time they get to the exam, not only do they have a game plan and a strategy going into the essay, but they also have practice on numerous amounts of issue spotting and writing, so they feel really comfortable executing that approach, and they know not only how to navigate their issue spotting, but also what issues are major versus minor, and major issues are those that need a little bit more analysis. We have subjects like constitutional law and civil procedure and real property that really require more of an analysis, but there are areas like evidence, which I'm going to go over right now, where you could have a racehorse question of up to 45 IRACs, which I've seen in some essays, pure evidence essays, meaning they're not crossing over with any other areas. And you really have to not only know how to navigate that through your issues and IRACs, but you also have to watch your timing and do a lot of practice. So in evidence, as the example, and you can see samples of my approaches on YouTube, and there's clips on Instagram, and of course all of our over 60 approaches come with the program. Evidence is definitely one of my most popular approaches, and it's probably because it's really easy to navigate once you get the hang of it, and it's one of the hardest areas to write for sure, just because of the amount of issues that they test in especially a pure evidence essay. So the first issues that you're always going to go into in any type of admissibility, whether it's an object, or typically you'll have witness testimony or documentation, is relevance. So you always want to go into both legal and logical relevance, and whether or not you're going to give more of an analysis here depends on the facts. So part of the approach is not just like a cookie cutter checklist telling you the issues that you have to go into, but I'm also describing whether or not you're going to spend some time on these issues given knowing the area of law and also the way that the California examiners test these areas. So logical and legal relevance you're always going to discuss. And within legal relevance, you have a sub-issue in California, which is Proposition 8. And in California courts, in a criminal context only, not civil, you cannot not allow in relevant evidence, subject to some limitations. So Proposition 8 as a sub-issue under legal relevance. And that's only discussed, again, if you have a criminal context California case. Now, bringing it back up to the call of question, make sure that you're paying attention to if they're asking for answer according to California law, which means that you have to apply the California Evidence Code and not just the federal rules of evidence. So that's really important to know the distinctions in your rules. And as you're getting out of legal relevance, you may have some public policy considerations in that item of evidence. You're looking for settlement offers or proof of insurance, and so on and so forth, all these different public policy considerations that could come up here. As you do your practice, you'll be able to spot what a public policy admissibility type of evidence looks like. They're not highly tested, but they do come up every now and then. And then as you're getting out of relevance in the totality, you go into one of the most missed areas, which is authenticity. And I used to be a trial attorney. I don't really practice that much anymore. I haven't really practiced in the last 8 years. I've been doing CA Bar Style for 15 and licensed for almost 15. But when I was in court a lot, you cannot get in an item of evidence that is not authenticated. And I don't know why applicants like to skip this prong a lot and this hurdle because you're establishing whether or not the evidence can come in. But if you have a lay witness, for instance, that has not actually perceived the event to which they are testifying to, that item will not come into evidence, and you may be done with that item of evidence in your essay. I have seen that happen on the California bar. So if you feel like you're pushing an item through these hurdles and it doesn't really sit right, you may not have properly authenticated it, and you want to go back and see this. It's not heavily tested in that fashion. Usually the item will be authentic, but just keep in mind that it may not be. So be aware of that. Now, other authentication issues are voice authentication. You may have the best evidence rule, secondary evidence in California it's known as, and also expert testimony. So you want to make sure you know the distinctions between California and federal there well. There's many prongs and IRACs to go into in both. And as you get out of the authentication, then you have a lot of consideration hurdles. So these are hurdles, I call them hurdles, the big ticket items. And of course, there's a lot of sub issues within each one that are all within the gamut of the approach, as well as their corresponding rules. And these are where you have to be able to look at the facts and identify whether or not that item of evidence fits within one of these hurdles. And those are areas like privileges, character evidence, impeachment, and hearsay. A lot of student essays that will come back definitely start with hearsay. And I understand why it's that big ticket area that we go into in law school. But of course, not every item of evidence is hearsay. So you really need to understand what hearsay looks like, what character evidence looks like, what impeachment evidence looks like, and of course, privileges to be able to identify it properly and determine if, based on that hurdle and the sub rules that are applicable to the facts, that item of evidence is actually going to be admissible or not. Make sure you know the exceptions and exemptions to hearsay well, and make sure you pay attention and know how to deal with double hearsay. Keep in mind that if you have a double hearsay issue, like let's say a business record, there's a police officer that took an eyewitness testimony at the scene of an accident, so you need to get not only the business record in as a hearsay exception, but also the witness testimony as an exception as well. Maybe there's an excited utterance there, a present sense impression. So make sure that you hit both hurdles, and within the approach I lay out, and this is on YouTube. We have, I think, the full evidence approach on there, and you can watch it. People literally have said very humbly that they've watched the evidence approach and they've gotten the highest grade on in their law school midterm or final. So it just gives you a snippet. And again, we have almost 60, and I'm going to be making about 20 more this year of just breaking down subcategories into approach. And all my approaches are based on 25 years of the California bar exam. But really the key is in evidence, back to evidence, once you've issue spotted the entire essay pursuant to hopefully an approach, not just concepts, right? I see this as hearsay. You've got to go into the issues like relevance and authentication that always need to be discussed. But once you've done that, you have to add up the amount of issues that you have. And you usually should spend about 10 to 12 minutes, ideally, issue spotting. That takes practice. So if you're like, how could I do that in 10 to 12 minutes? You can. It's just going to take a lot of repetition to get your time down. And then, and also, of course, having an approach that you've worked through and knowing the testable universe of issues. And then you want to write within the remaining allotted time. So there's an hour. So let's say you have like 48 minutes to write. You take the amount of issues that you've spotted, you divide them into the remaining amount of time. And maybe that'll give you 2 minutes, 2.5 minutes per IRAC. Let's say you have one issue when the clock strikes, maybe it's 11 a.m. By 11:02, 11:03, you got to be that disciplined to get out of that IRAC. So you got to literally force yourself, even if you have more to say, even if you know that issue really well, you have to force yourself out of that IRAC so that you don't run out of time. Because with evidence pure essays, you can start running out of time. And if it is, let's say, essay 1 or 2 or essay 4, it can start cutting into time of the other essays, or maybe even the performance test, which is a big no-no and you do not want to do. So that's just an overview of what an approach looks like and why it's so important to have a game plan going into your essays. I'll be doing more and more of these. If you have any questions, please ask them below. and good luck on your evidence essays. I would recommend practicing at least 4 to 5 closed book within the gamut of our CA bar style evidence essay approach. Good luck.